It's the basics, ma'am. You asked me what the size is. That's the critical question. So we're asking how many feet approximately.
He doesn't know. What's his answer?
So how do we get an answer, Mr. Leo? Is there any way to get an answer to that question? Do you have a survey, Mr. Leo?
Are you getting off of his testimony now?
No, I'm asking about, is there any boundary survey that you and or the office has in your possession?
Yeah, he didn't testify as to any survey, sir.
I'm asking if he has ever looked at any survey of that land parcel. Mr. Leo?
You can answer that, Mr. Lyon.
I only reviewed what I was provided in 2006.
You don't answer the question. Was there any survey?
Did you look at a survey, Mr. Lyon, of the property?
No, I did not.
Okay, so then how did you determine the boundary of the Gulf of Mexico?
Okay. He didn't say that he had determined the boundary of the Gulf of Mexico. He testified that the property that abutted the Gulf of Mexico.
No, no. He stated that the boundary is the Gulf of Mexico. So where did you get that information from, Mr. Leo?
Sir, your time has expired for asking questions. It's now 1:15, as I told you.
Ma'am, you're shutting me off, I think. That's, we're reading the question back. You're corrupting this discovery process. Yeah.
And sir, your time for questioning
It's not over.
ended.
He hasn't answered the question.
And at this point in time, I'm going to allow the property appraiser has any other witnesses that they wish to call?
I'll call George Bussett.
Okay.
Has any court, in any case that you filed, found not been dismissed?
The 11th Circuit, sir, determined that the petitioners are the owners of...
In fact, isn't it true that in
I
the
haven't
case
even-
you
I have-
refer to...
Mr. Peterson, I finished.
Let him finish your question.
The
You're
11th Circuit,
overwhelming the court
which is
reporter.
the United States Court of Appeals for the 11th Circuit, determined, and this is a dispositive determination, that the petitioners are the unimpeachable record owners of said land parcel 12 4420 01 000 15 0158, I quote, on the Gulf of Mexico, as Mr. Aleo also stated, which is adjacent to the park. That was a dispositive determination of the ownership issue. That's what all the cases turned on. Now, Mr. Peterson, you have been
Why don't you
involved-
let me
Mr.
answer,
Peterson,
ask
no.
the question,
You have
sir?
been in,
Gentlemen,
you have been in...
sir.
Objection. If he wants to argue, save it for argument.
I'm sorry, I'm going to finish my answer. You have been involved in a bribery...
Gentlemen. I don't find other cases as being relevant in any respect, so I see no need to continue that line of questioning. So if you have any other questions for the witness, you can proceed with those questions.
Isn't it true that the case you referred to was dismissed by the Federal Court of Appeals?
Defendant, are you referring to the case in which Richard A. Lazara was a defendant and therefore under an absolute recusal obligation, just like Judges John Edwin Steele and Magistrate Polster Chappell and Douglas N. Frazier? Is that the case you're referring to?
Okay, let me direct this again.
I'm through with my questioning. I think
cases pending in other jurisdictions.
Oh, they're not pending. They've all been dismissed.
That doesn't have any effect on my ruling as to this matter. What's been filed in any other jurisdiction or court is not applicable.
Just one
So
more
we
question.
don't need to go down that line of questioning.
Were there in fact any beehives anywhere on that island that you put there?
Yes, there were. They were on the riparian Gulffront parcel of an approximate size of 2.5 acres. Mr. Aleo today stated on the record and answered that that parcel, that riparian parcel, is bounded by the Gulf of Mexico. Therefore, it could not possibly be having a depth of 135 feet, but more than 2,000 feet. He did not look, by his testimony, on the street land, and you know, Mr. Peterson, that the fires within a private residential subdivision burned down more than 200 acres. That's a criminal and reckless act. I hope that answered your question.
Any other questions for this witness?
Oh, I think we've heard plenty.
Mr. Alejo, let me just clarify, there was no application made for tax year 2009, and therefore no denial was issued as you received no application. Is that correct?
That is correct.
All right, I'm going to allow each side a 5-minute closing summary. It's 10 minutes of 6. The petitioner may go first. You have 5 minutes to summarize. Then the property appraiser may summarize, and then I'll issue a ruling on that.
Right. Right. The officials have facially failed to properly characterize the property and land parcel applied for. On questioning, Mr. Alejo stated that he only looked for beehives within 50 by 135 feet of an area. However, the riparian land parcel in question, in dispute here today, is bounded by his own admission and by the admission of other Lee County officials, and of course by the prima facie evidence of the plat. It's bounded by the natural boundary of the Gulf of Mexico. Therefore, it is nonsense to say that he could have possibly seen the agricultural use when he only looked in approximately a 1/17th of the entire land. I also contest that we didn't file it. Apparently, you suppress evidence like a riparian, like a Gulf of Mexico boundary. We object to that statement, that we did not apply. We object to the mischaracterization of our record title, of our record ownership. We own, pursuant to the 4/21/2009 11th Circuit dispositive determination, we own a riparian lot on the Gulf of Mexico. The plat says so. We're also referring to the case of Lay versus State of Florida Department of Environmental Protection. We are referring and adopting by reference in this presentation the case before the 11th Circuit of West Peninsula Title Company, which references Caples versus Taliaferro and supports our record ownership of that street land where Mr. Alejo never looked. Again, ma'am, I perceive prejudice. You asked me what the size and the area of the lot is. When we asked to ascertain the exact boundaries which are governed by the Gulf of Mexico, you interrupted us and blocked discovery. However, we were lucky. Mr. Alejo had already determined that pursuant to the plat, the conveyance is our conveyance of a approximately 2.5 acre riparian Gulf front lot. We again object to the allegation that we didn't file an application, and we are also we're referencing the mailbox rule. There's ample evidence of our application. We're considering this another attempt to misrepresent our ownership as it was affirmed and dispositively declared and adjudged by the 11th Circuit. The case was Prescott. She is a petitioner. The judgment can be found on the public record. We are the owners of a riparian lot, and that riparian lot is not 135 foot deep. Any natural boundary supersedes any fixed measure or distance. This is a Gulf front property which is constantly